This is Francis Walker versus Sheila Fishburn. Each party will have 15 minutes to present oral argument. The appellant may proceed first and may reserve up to 5 minutes for rebuttal. We are a few minutes early. Is there, do we need to wait for not witnesses, but clients or anyone?
No, Your Honor.
Okay, all right. We have read the briefs. We're prepared to proceed. If you would just come up to this closest podium.
Thank you, Your Honor. May it please the Court. My name is Jessica Philemon, and I represent the Midview Local School District and its employees on appeal. I would like to reserve 3 minutes for rebuttal, please. We respectfully ask the Court to reverse the trial court's decision because the Board of Education and its employees are immune in this case. Addressing first the Board of Education's immunity. The general rule under Ohio's political subdivision tort immunity statute is that a Board of Education and its employees sued in their official capacity are immune unless an exception to that immunity applies, in which it is plaintiff's burden to prove. Plaintiffs here argue that only one exception applies, and that would be the exception under Revised Code 2744.09b. That exception reads that where an individual brings an intentional tort claims for a matter that arises out of the employment relationship within the meaning of that section of the statute, then that exception may apply to immunity. Most recently, the Ohio Supreme Court in its decisions in Vacha and Sampson have considered what it means to fall under that exception to immunity, and the Supreme Court has explained it's not an absolute bar to immunity. In other words, anytime an employee brings a claim against their employer, that matter does not necessarily arise out of the relationship. And so the Supreme Court defined what this statute means to say that it requires a causal connection or a causal relationship between the claims brought by the employee and the employment relationship. Plaintiff here is unable to meet that causal connection for 3 very distinct reasons. Any one of these 3 reasons alone is enough to break that causal connection. The first is because of the independent investigation that took place here. Plaintiff's nucleus of claims arise from a day where she called off sick at Midview Schools. She was a bus driver. She had told a coworker of hers, Julie Piazza, that she would no longer be coming in on Tuesdays to work in a substitute role where she would be paid because she was going to start working at her second job. So as a bus driver, she had a short period of work in the morning and a short period of work in the afternoon. But during the day, on those Tuesdays, she would usually pick up some more work. And she was saying, I'm not going to be doing that anymore because now I'm going to be working in Eaton Township. And it was noticed by Julie Piazza, a coworker, that plaintiff had started calling in sick for the entire day on Tuesdays, morning and afternoon bus routes. And so in her own curiosity, she decided that day, that Tuesday, plaintiff called in sick. She decided that she wanted to find out what plaintiff was really doing.
Was she at work at the time that she decided?
Yes, Your Honor. She was at work and she had learned that plaintiff had called in sick that day. So while she was at work, from work, she called her mother, who worked at a furniture store, and asked her to call the township to see if Fran was working. The mother didn't do it. She asked her employee, John Kaiser, to do it. He did it. He called and said, is Fran there? The secretary who answered the phone, who was not Fran Walker, the plaintiff, said she is and went to get her. Meanwhile, John Kaiser hung up the phone. That was it. So that's plaintiff's nucleus of facts that she's alleging in this case. They are born out of this independent investigation that was performed by Julie Piazza. And courts in Ohio have held an independent investigation by a coworker would sever any causal connection between the employee and the employer because it's not the employer's action, it's that of a coworker. There's no causal connection. And those 2 cases are the Jopeck and Marsh cases. Jopeck's out of the 8th District, Marsh is out of the 12th. Marsh is really relevant and really similar to our case. Because actually in Marsh, it was a coworker who was suspicious of another coworker making obscene phone calls from the Middletown Police Department to another coworker and chose to independently investigate. In both of those cases, the Court of Appeals said no causal connection, immunity is upheld in the case because the independent investigation would break any claimed causal connection. The second distinct reason that plaintiff can't meet the causal connection is because of the lack of alleged employer conduct here. And that really goes to the heart of the Ohio Supreme Court's decision in Vacha. In Vacha, which came from the Lorain County Court of Common Pleas and up to Your Honor's Court, the Ohio Supreme Court considered this 274409 exception. And in that instance, the Lorain County Common Pleas Court had not done a first instance analysis on immunity. And so the Ohio Supreme Court said, because the trial court didn't, we also are not going to. But they wanted to give an example of what would clearly not fit within the definition of this causal connection. And at paragraph 25 of the Supreme Court's decision, they said this. They said an example would be where the plaintiff bases her intentional tort claims on the actions of a coworker's conduct rather than the employer itself, and that those claims clearly lack a causal relationship and are outside the scope of 274409 as a matter of law. We would submit that is the same example here.
How are we to, and I want you to keep your thought because you had 3 points and you just made 2. But how are we to look at the argument that you make on the one hand that this was an independent act, and then later in your brief you say that she was not clearly outside of the scope of her employment, that your opposing counsel makes that point in the brief?
Yes, Your Honor, thank you. So that argument that my opposing counsel makes goes to 2 different issues. The first issue is whether or not the Board of Education has immunity. And the Board of Education has immunity so long as plaintiff can't prove that causal connection between the employer and the employee. And so Julie Piazza's independent investigation breaks any causal connection. Therefore, the Board of Education is immune. The other argument, though, is whether or not Julie Piazza was acting within the scope of her employment. And that issue goes to the heart of whether she herself is independently immune as an individual, because she was sued in her individual capacity.
But how can you reconcile those 2?
Yes, Your Honor. The reconciliation is this. An individual is immune under the law so long as they don't do 2 things. They don't act manifestly outside the scope of their employment, and they don't act recklessly or in bad faith or with willful or wanton misconduct. So, looking at that, this court issued a decision last year in 2015, the Thomas case. That involved a building commissioner who both condemned and tore down, demolished a home, and the homeowners sued him and the city. It was a city building commissioner. And the city argued that he was immune in the case. Well, the homeowner said, no, you're not immune because you weren't authorized to demolish or condemn that home. Therefore, you acted outside the scope of your employment. And this court, the 9th District, held, no, that's not the case, because even though the building commissioner wasn't authorized to do what he didn't do it with the intent to cause harm. And the court found that, therefore, that individual did not act manifestly outside the scope of their employment. And we can think of lots of examples where an employee might do something that's not in their job description, so to speak, but they're still acting within the scope of employment, or rather not manifestly outside the scope. So Julie Piazza, even though her employer didn't authorize what she had done, it did not give her permission beforehand to do it. It also was not in her job description. She was at work when she did it. And certainly we can find examples where an employee would be asked in a role similar to Julie Piazza's to assist with an investigation. So what she did, being at work and doing it, was not manifestly outside the scope. just like that building commissioner in this court's Thomas case, where the building commissioner didn't have the authority to do what he did in condemning and tearing down a home.
Thank you.
Thank you, Your Honor. And to get to the third point, as you raised, I ought not forget. The third point, Your Honors, is the intervening acts. And so as this court, in the Lytle decision, considered what is a causal connection, the court said that a causal connection in Lytle is synonymous to proximate cause. So you're looking for that proximate causation. And in Lytle, this court explained that any causal connection would be severed by an intervening act. There are at least two intervening acts here. The first is, of course, that independent act by the coworker, Julie Piazza. That's clearly an intervening act that would break any causal connection. The employer didn't authorize it, didn't know it was happening. The second intervening act is the fact that it was that employee, John Kaiser, who called the township to check on plaintiff. So at this point, we are so many steps removed from Midview Schools. Plaintiff's claim in her complaint is that she learned that someone named John had called her at her second place of work. She initially was concerned and became paranoid that maybe her superintendent was checking in on her because his name was John Kuhn at the time. And so she was curious, maybe they're checking up on me to see if I'm calling in sick to go to my second job. So she called the school to find out if he called. They said, no, John didn't call you. She called the police. The police traced that call to Eaton Township, discovered that it was the man named John Kaiser who made the call, and the police said to her, he's a registered sex offender. In the police report, she was noticeably very upset to find out that the person who called, she didn't know why he had called, and he's a sex offender, a registered sex offender. That is what caused her extreme emotional distress. Not that Julie Piazza made the call, not that Julie Piazza told her mom, Sheila Fishburn, but the fact that this guy, John Kaiser, a registered sex offender, called her. And so that in and of itself is, again, an intervening cause. I'd like to address two of the Board of Education claims specifically. The first is the negligence claims, because in the initial complaint that was filed, later plaintiff amended to add the retaliation claim. In the initial complaint, plaintiff brought several intentional tort claims, but she also brought some negligence claims. She brought negligent hiring, negligent retention, and negligent supervision. The significance of that is that even if plaintiff were to win on this idea that that exception applies, that 2744.09 exception, that exception only can apply to intentional tort claims. It says it on the face of the statute. So even if the court were to find that exception applies, the negligence claims must be dismissed because they're negligence claims, and that exception would not apply. The second is with regard to the retaliation claim. In plaintiff's complaint at paragraph 68 to 70, she's clear what her retaliation claim is based on. And she says it's based on her constitutional right to sue. In other words, I sued you, school district, you retaliated against me. That in and of itself shows that retaliation claim is not a causal connection to the employment relationship. It's based on her constitutional right to sue. Now,
Does that considered in a vacuum, or constitutional right to sue considered in a vacuum?
I don't think it's considered in a vacuum, Your Honor.
If it's not, then it appears as if it would be necessarily connected to her employment.
In the analysis, I would submit that it's not for two reasons. One, because she is saying it's based on this constitutional right to sue. And second, because if there's no causal connection for the underlying claims, then there ought not be that causal connection for the retaliation claim. With regard to plaintiff's discipline,
I was going to ask, why didn't she just grieve it?
thank you. That's where I was going, Your Honor. Interestingly, plaintiff was disciplined. She received her suspension for those days she took for sick leave, but then went to work for the township. She had a right to grieve it. She had a right to appeal it. She knew of those rights. She did not invoke those, and instead she elected to then bring this retaliation claim. In the record, it's a curious set of facts. Plaintiff suggested to her union rep, I bet that they will ask me to dismiss my civil suit in order for me to have success on this if I were to grieve it. And she suggested that. So plaintiff alleges in the retaliation claim something else, and I appreciate that we're not here today to talk about the merits of that retaliation claim, but we would submit that it is not causally connected, and it's curious in its creation in this underlying suit. With regard to the individuals and their immunity in the case, there were two individuals that were sued. Susan Babola, she's an administrative level employee. She was the director of facilities. And second, Julie Piazza, who we've spoken about, who was the transportation secretary. Employees under the revised code are immune unless they act manifestly outside the scope and with the mens rea that we discussed, that intent to cause harm or reckless behavior. The exception that we discussed under 274409 for the causal connection has no application at all to individual immunity. And it says that explicitly within the statute, that it only applies to the political subdivision, and the Ohio Supreme Court said so in Zumwalt. So it doesn't apply here. With regard to
I'm
Susan.
sorry, I've been listening to your argument, and the time has expired.
Okay.
But
well,
that was my fault, so I'm going to give you just a couple of minutes
Okay.
For rebuttal, but I was supposed to have reminded you when we got to.
And I didn't bring my iPhone because I was afraid it would start buzzing or something.
Okay.
Okay,
All right.
thank you, Your Honor. I'll pick that up when I get back to the bench.
All right.
Thank you.
Good morning, Your Honor. May it please the court. My name is Chris Caffrell. I'm here on the plaintiff with the appellee in this case, Francis Walker. This appeal arises out of a ruling on a motion for summary judgment where the facts must be viewed in light most favorable to the non-moving party. While immunity is a question of law, the facts are what the court must base its decision on. And when deciding the issue of immunity, and if genuine issues of fact remain after reviewing the party's motions in response to the motion for summary judgment, then the court properly denied the motion and reserved its decision until after the evidence could be presented. There's no trial. My point here is the fact that the trial court may not have had enough information to decide the issue of liability at the time when it denied the motion for summary judgment based upon the constraints of the summary judgment motion. The issue here in the case revolves around immunity and to whom does it apply. There are several claims that have been brought, and it's not an all or nothing proposition, meaning that just because immunity may apply in one case does not mean it applies in every single claim brought by the plaintiff. Starting with the intentional infliction of emotional distress, the negligent infliction of emotional distress, and the issue of the invasion of privacy claims, those are all sort of related. We'll talk about Midview first and whether it would have immunity. As pointed out, our argument is around the issue that under 2744.09b, if the claim arises out of the employment relationship, then there would be no immunity. We believe that the situation here is similar to that in case of Buck, which stated that what happened in Buck was there was a police sergeant who sent a letter to a village council members regarding the performance of the chief of police. This investigation was not done at the behest of the village council. However, the village council received this information. They processed the information. They put a notice of the behavior of the police chief on the public record, which caused damages. The village acted on this information. And this is very similar to what happened here. The action by the secretary, the investigation, was essentially ratified by Midview. Midview received the information, used it for its investigation in determining that they wanted to discipline Ms. Walker for their belief that she abused her sick time. Obviously, she states that that's not what happened. She was sick that day. She stopped by the office on her way home to pick up her medications. She wasn't there for more than a minute or two before the phone call happened.
Was there, I noticed in reading the brief that you responded to the incident on that particular day, but it seems as if there were other days for which your client was sanctioned with, I think, 4 days, and then she was given an 8-day unpaid suspension.
Yes, Your Honor.
I didn't recall any factual analysis of the other
Sure.
days.
I believe that the discipline regarding those days, she had indicated that she had excused notes for those days, that there were, for example, indicated, page 4 of my brief, that she had valid medical excuse during some days in question in February 2012. As far as another issue she had, her activities were within the scope of her employer, I'm sorry, did not exceed the scope of her medical restrictions on that day. She'd also received pre-approval for a paid personal day, and it basically communicated with her employer for those days in advance. I think those particular days in that investigation really falls under the umbrella of retaliation and the civil conspiracy claims, because in those cases, what the court looks for is whether there's constitutionally protected conduct. And as this court pointed out, it's not looked at in a vacuum. Otherwise, there could never be this exception. And the issue here is, who did they sue? She's suing the employer. She brought a claim against her employer. And as a result, the school district had adverse employment reaction to it. They waited a year and a half to discipline her for any of these prior incidents. She's the only person to ever be disciplined in the last 5 years for any kind of abuse of sick time. That investigation, that secondary investigation, didn't happen until after she filed her suit. She'd already filed her suit and brought it before they decided, let's see what else we can nail her for in the past, when they had not done this with any other employer. They had, while the appellants state that it came out during discovery, they had that information in advance. They knew, based upon their belief that she had abused sick time on the day of the phone call, they knew that there could be an issue with other days. So they had the opportunity then to think, maybe we can go back and investigate it. They didn't need to wait for discovery to figure out that there could be other issues to investigate. They waited until after suit was brought. They actually had a meeting with her where they told her that, where it was suggested that if she dropped her suit, that they would not worry about the investigation, they wouldn't worry about the last chance agreement, things like that.
Was the union involved in that?
My understanding is that it was. I don't recall off the top of my head if it was or it wasn't. Going back briefly to the issue of Midview and whether they should be, whether it arose out of the employment relationship, these claims, we believe that they were. The actions here by the secretary investigated the performance of Ms. Walker. Midview received the information. They didn't do an investigation beyond what she did. They adopted and ratified the information by this employee and acted on it as if it was fact. Midview told Walker that she persisted in her claims against them, she would suffer adverse employment action, and these actions did cause harm to Ms. Walker. Additionally, another employee, Ms. Cardamore, had discussed this with her at the office, had discussed with Piazza at the office about these days that she was missing. And the circumstances were taken as a whole view that they certainly adopted what was done as their action. The appellants also talk about that the actions of Piazza were an intervening act. I don't believe they were, because they were adopted and ratified. Bless you, Your Honor. They were adopted and ratified by the school district. In addition, the actions of John Kaiser certainly couldn't be an intervening act. They were done at the behest of Piazza. They were done as a request. He certainly wouldn't have investigated on his own independently.
How do you argue that the actions were adopted and ratified where Piazza was given some adverse employment sanction?
It was down the road, Your Honor, and I also believe that because they didn't do their own independent investigation, they took what was done by their employee and used it. So even if they gave her some menial discipline.
But how would a district ever know or ever be suspicious of an employee misusing sick time unless they got something from somewhere? Do they just
My
spontaneously go look every time somebody's absent?
I understand that, Your Honor. I think that there should be someone in the school system whose job it is to
Hunt
review
down
these
these
things.
people?
What's that?
Hunt these people down and make sure that they're all where they say they're supposed to be?
If they see a pattern, there certainly should be, it's just supervisors and things who can certainly look at the pattern of activity. If they become suspicious, then they can act on it. That's what they can do. And in this case, they took the information and provided it to them by Julie Piazza, and they acted on it. Essentially ratifying that, her investigation and the way she behaved, because they didn't do any other independent investigation.
Well, if they didn't do anything and they had this information, wouldn't that reflect badly on the district, that they knew that they suspected employees were misusing sick time and didn't bother to pursue it? What kind of a message does that send to the other employees in the district?
But she's the only one who received any discipline from it. In the past 5 years, there was only one person they went after. It was as a result of Julie Piazza's actions and the district's action, they went after Ms. Walker. And then after she brought her suit.
Do we know that the cases where you say they never went after the employee for violating the policy? How can we conclude anything from that statement? They may not have gone after it because they didn't have enough, or they found out that they were wrong. I don't understand how we can just take that for granted.
I understand that, Your Honor, but there's no other investigations that
we know of.
that we discovered during the discovery. She's the only one disciplined. I don't believe there was anyone else investigated it. There are no evidence that they investigated anyone else. Moving on to the defamation claim and whether Midview was immune, I think it goes back to the same issues that were raised in Buck. The information that was put in her file was untrue. At least arguably it was untrue. It was published to her supervisors and potential future employers by the information put in her file, which was directly related to her employment. And it's clear that it was connected to her employment, which would get rid of the immunity, and it caused a loss of esteem to her and her employers and her potentially future employers.
Isn't there a mechanism in place for her to contest the information that's put into her employee file?
I believe there may be, Your Honor.
Should pursue that?
Not that I'm aware of. I think, but Your Honor, I don't know if that necessarily in and of itself means that she needed to do that in order to have, particularly it relates to the retaliation claim. I don't know that she necessarily needed to object to it. That the action was done in advance. She filed an injunction. She filed an amended complaint when they came after her for her bringing of the suit. And I think it's clear that she did things through a different method through the court system, because her court had already been filed. The initial complaint had already been filed when she brought the retaliation claim. To when this discipline had happened was after she had already brought her file. So she, instead of grieving it, I think she chose to continue on with the court case and bring it up in the court case as a retaliation claim, because the case was already pending before the court. Lastly, Your Honor, as it relates to the issue of immunity in Julie Piazza, even if I think the court is correct in that it's unclear whether the actions of her are within the scope of her employment or not, I ultimately believe that it's within the scope of her employment, as I indicated, because of the ratification, adoption, and the use of the information Piazza provided to the school district. But even if it's within the scope, she can still lose her immunity if her actions were done with a malicious purpose and intent. In the facts in this case, Piazza had gotten used to Ms. Walker helping her with her work and job responsibilities, had been helping her frequently with her work and job responsibilities. When Walker got the job with the township, she didn't have much time to do those things and to help Piazza with her job. We believe that Piazza started this investigation partly as retaliation for not helping her out. And her intention was malicious. It was to cause harm to Ms. Walker. So for those reasons, we believe that it's outside. We believe that the individual immunity should not apply to Piazza. Your Honor, I would ask that this court uphold the trial court's decision, and thank you for your time.
Before you take your seat,
Yes,
there
ma'am.
was one matter that I wanted to clarify, and I'm not sure, I think that it was in your brief. It related to, there was a reference made to that last point about how your client at one point was helping one of the other employees. It's here on page 2 of your brief. You say, prior to beginning her term as fiscal officer, Walker would often assist Piazza with her work. However, after winning the election, Piazza learned that Walker would no longer be. It's not clear who won the election. Is the fiscal officer an elected position?
Yes, Your Honor.
Oh, so it is.
So it was Walker had, I'm sorry,
Walker.
Walker had become the elected official in that
I
case. And
see.
because of her new job responsibilities as the fiscal officer, she wasn't able to assist Piazza.
I understand, okay. That wasn't clear to me. Thank you.
Thank you, Your Honors.
And counsel, you're going to have 2 minutes remaining. Well, I'm just going to give you 2 minutes because I'm sort of don't see the
For all the
spreadsheet.
blame here. Thank you very much,
Go
Your
ahead.
Honor. Initially, I would just like to address some of the record references made by opposing counsel. I appreciate, again, that this is not a merits question, it's not a unique question. But with regard to the retaliation claims, there is a reason that plaintiff was disciplined 1.5 years after she abused her sick leave. And that is because discovery in the underlying case included public records from Eaton Township. And when those records were reviewed by myself and the superintendent, it was discovered that plaintiff was working at Eaton Township when she was calling off sick from Midfield. And courts in Ohio, appellate courts unanimously hold, when faced with information of misconduct by an employee, the employer has to act. And so that is what Midview did. Plaintiff recognized and conceded below that the employer wasn't able to ask about her whereabouts under the sick leave policy of the labor contract. But when they received that information from Eaton Township that she was working, it was clear that it was a violation of the labor contract, and she was disciplined. Others were disciplined for abuse of sick leave as well. Plaintiff is not the only one who was disciplined, as opposing counsel referenced.
Is that in the record?
That's in the record. It's in Superintendent Goggins' deposition. There are at least 3 others that he listed by name in his deposition that we also referenced in our motion for summary judgment with specificity in the retaliation portion of our MSJ. Judge Schaefer asked, how could an employer not act? And that's exactly what Ohio appellate courts say. We must. That's the Pearl case and others. After her discipline, plaintiff signed a waiver with the superintendent that she would not bring any dispute for her discipline. Opposing counsel mentioned the Buck case. That's this court's decision from 2010. It's not decisive here. It came before the Ohio Supreme Court's decision in Vacha and Sampson, and it also was on a motion for judgment on the pleadings. There was no record considered, and in Buck, this court said that 274409 may apply. It simply remanded that case to the court below to consider. It didn't make a decision on whether or not it applied.
And you have reached the end of your time.
Thank you very much. We ask you to reverse.
Thank you both for your presentations. The court will take the matter under advisement, issue an opinion which will be sent to both parties. Please check the Supreme Court website as well.
Thank you.
Have a good day.
Thank you, Your Honors.